John Tinder. I served on the U.S. District Court for the Southern District of Indiana from 1987 to late 2007. And then after that, became a judge on the Seventh Circuit Court of Appeals, where I served until near the end of 2015. And I retired and am happily retired ever since.
I'm David Hamilton. I joined the Southern District of Indiana as a district judge in late October of 1994 and served in that capacity until November of 2009. I spent the last 2 years or so as chief judge in the wake of Judge Tinder's appointment to the Seventh Circuit, since he otherwise would have inherited those responsibilities. Then in November of 2009, I joined the Seventh Circuit. I continue to serve that as an active circuit judge now. It's October 2022 as we're recording this, but in December 2021, I sent notice to President Biden that I plan to take senior status after I turned 65 and upon the appointment of my successor. And Magistrate Judge Doris Pryor has been nominated, and we are awaiting her confirmation, at which point I'll become a senior circuit judge.
I think, of course, both experiences were remarkable from the nominee's perspective. There's a lot of anxiety, not knowing what's going to be the concern of the day and so forth. My district court nomination process was probably a little more exciting than the circuit nomination hearing. At the hearing for the district court nomination, there were 2 or 3 circuit judges nominated at that time up for hearing, and 4 or 5 district judges. So we district judges sort of hid in the background watching the circuit judges get all the tough questions. And the one right in front of me was a nominee from the 5th Circuit. His last name was Smith, I think. Can't recall his first name. Anyway, he had served as in a very political position, county chairman of Harris County, Texas, Republican chairman, and had made some statements that were very controversial. For example, he referred to the League of Women Voters as the plague of women voters. And my wife, who was seated next to me, grabbed my thigh and said to me, "You haven't said anything stupid like that, have you?" So fortunately, I had not. And after they were finished with Judge Smith, and they turned to me, it was much milder. But as I recall, it was terrific to get the local support that I had for the nomination, having both Senator Lugar and Senator Quayle introduced me for the nomination, as well as having Congressman Andy Jacobs Jr. come in support of my nomination. So that was very comforting. And then later, when I was nominated to the Circuit Court, Senators Lugar and Senator Bayh both appeared on my behalf to make the introduction. So that having that sort of bipartisan support really eased the way through for me.
I will say that at least speaking relatively, Judge Tinder's confirmation process for the circuit looked far smoother than mine. In hindsight, we went through the process 2 years apart, and with the same 2 senators from Indiana, Richard Lugar, a Republican, and Evan Bayh, a Democrat. But my Seventh Circuit confirmation process was considerably more controversial. I was President Barack Obama's first judicial nominee, nominated in mid-March of 2009, just a few weeks after the new administration took office. And it eventually became clear that the administration had decided to lead with me among several possible nominees as an attempt at a kind of peace offering to try to still or bring peace to the judicial confirmation wars that had been fairly ferocious during the tenure of George W. Bush, and before that during the Clinton administration. At least the idea was Hamilton would be an experienced district judge with a reputation that was at least fairly moderate and had strong bipartisan support from both the Republican and Democratic senators from Indiana, as well as from others in Indiana. There were, however, other factions within the Republican Party that were not ready to declare a truce on the judicial confirmation wars at that point, and decided to oppose my nomination pretty quickly, focusing on a few controversial decisions that I had made over the years as a judge in a state that was relatively conservative and whose legislature in the past years had taken some controversial steps on so-called culture war issues. I'd made some controversial decisions, and those became the focus. And ultimately, I got out of committee on a party line vote, and then my nomination sat on the floor for a while. There is a link between my nomination and Judge Tinder's in the role of Senator Sessions. Judge Tinder may or may not want to talk about the role that Senator Sessions played when he went on the district court. But by the time in 2009, by the time I was up for the circuit, Senator Sessions decided he would use his role on the Judiciary Committee to try to oppose my nomination and lead a filibuster against it. This was at a time when filibusters were still available on judicial nominations, changed a few years later. Senator Lugar took the lead in working within the Republican caucus to try to oppose the filibuster that Senator Sessions attempted. At that time, the Senate was 60 Democrats and 40 Republicans. And if all 60 Democrats voted in favor of me, they could defeat a filibuster. But Senator Lugar brought 9 of his colleagues along with him, and so there were 70 votes to defeat the filibuster and bring cloture and allow me to pass. In the final vote, John and I both have in our offices, I suspect, the vote tally sheets that Senator Lugar provided to us with the pencil mark, the ticks of the votes as the senators cast their votes. John, as I recall, passed through on 97-0. Was that it?
93-0. There were some folks out running for president at the time.
Okay,
So
okay, more than I thought. Okay, and, my case, it was 59-39, with 39 Republican votes against me and 1 Republican vote to confirm, that coming from Senator Lugar. I'll share, if I may, one other story or a couple of other stories about the process that I might or may not be of interest to you, but one of the most memorable parts of the process for me was that it included a White House visit the day before my nomination was announced, including a brief Oval Office visit with the new President Obama and his staff. And both my wife, Inga van der Kruijse, and I were able to meet the president and chat with him for a few minutes. The photos are treasured souvenirs. While the controversial nomination went on, Judge Tinder and my wife Inga very generously followed the blogs and the political controversy surrounding my nomination for me and told me not to go online and look at any of the commentary, which turned out to be great advice. They sheltered me from that. It minimized my stress in the process. And the last thing I'd like to say about the subject is the importance of the bipartisan support, not only from the two senators, but also from members of the bar and people who had known my work over several decades in Indiana. I'd particularly want to highlight Peter Rustoven, former associate counsel to President Reagan, and Jeff Slaughter, now a justice of the Indiana Supreme Court, who provided strong, outspoken support in favor of my nomination, even though we might well disagree on quite a few legal issues. It was a reflection, I think, of mutual respect. Certainly, I for them, and I think they for me, as legal professionals who could bring sound judgment, even if you don't always agree with the result.
By the way, all that I could add about the Jeff Sessions part of the nomination process on my behalf is he was a stark reminder for the rest of us who were being nominated at that time of how bad it could go. Jeff was a U.S. attorney at the same time I was back in the mid 80s and got nominated to the district court, and his nomination was defeated because of some very stupid things he had said when he was U.S. attorney. He returned to Alabama, ran for Senate, and the first Senate appointment he got was to the Judiciary Committee. So he spent a lot of time making other judicial nominees uncomfortable, as Judge Hamilton described. So that he, of course, went on to become one of President Trump's many attorney generals, at least for a while. I would say that there's certainly a lot more interest in circuit nominations from a variety of interest groups across the board. There are these what I would call war rooms where people are researching very carefully every circuit nominee. I assume some district nominees as well, but the focus is clearly on circuit nominees. And the attention paid by the members of the Judiciary Committee is much closer to circuit nominees, in my opinion, than for district nominees. That was my sense. I don't know, Dave, you may have some feelings about that.
No, it's certainly true. And it also shows up in the just in the politics of the original selection, in the distribution of power between the White House and the Senate. We all are used to the idea that presidents decide whom to nominate for the Supreme Court. And it's also, I think, been true that presidents ordinarily defer to home state senators, at least of their own party, with respect to district court nominees. The circuit nominees are somewhere in the middle and a little more of a jump ball politically between home state senators and the administration. I was fortunate in my case, and I think and Judge Tinder was as well, that the senators were able to reach a fairly quick consensus with the respective nominating presidents for our circuit appointments.
True.
But we certainly know of colleagues around the country where there has been a serious tug of war between the White House and Justice Department on the one hand, and home state senators in the other. When those kinds of things happen, the potential nominees basically are best off just ducking and and trying to stay out of the way.
as a district judge, I set the schedule on everything. I determined what cases would go in what order, what weeks would be set aside for certain trials, when sentencings would be, and so forth. And really, I controlled the schedule. I described it as sort of being the engineer of the train that kept the train moving and decided how many stops to make along the way. And then suddenly, when I'm on the circuit court, I'm a passenger on someone else's train all of the time. My schedule is set by somebody else, by argument days, and by availability of other judges at certain times, and so forth. And so the schedule was out of my hands for the most part. Now, one of the good things about being the schedule maker as a district judge is every now and then these happy events would happen, like a case would settle at the last moment before a 2-week jury trial, or something of that nature. And all of a sudden you had 2 weeks where you thought you were going to be stuck in court, but you could actually get some other work done. Unfortunately, on the circuit court, that never happens. When an argument is set, when an argument takes set, they take place. You better be prepared, and they just don't go away. So you lose that little extra benefit. So that was one of the things that really struck me. And secondly, the volume of cases that a district judge has is many times what a circuit judge has at any given time. But the depth to which you go on each case is so much greater. You're reading into the record and trying to catch up with where the lawyers are so often. And that's, there are so many issues floating around in district court cases, but some of them aren't as important as others. Whereas in the circuit court, when you have issues in a case, you really need to drill down on those. And the depth is so much greater on a smaller volume of cases, but the amount of reading I found myself doing was several times what I was reading on the district court.
Mm-hmm. And that I agree with those observations. Obviously one of the greatest changes is simply that you can't do anything by yourself anymore.
Mm-hmm.
You need at least one other judge's vote to do almost anything, and certainly anything substantive in a case. So you go from being the only decision maker in your district courtroom to becoming more of a diplomat, somebody who needs to work in partnership with other judges and who needs to we all need to try to pay attention to one another's thoughts, views, and even egos and feelings from time to time. So that's a big change. Another big change in work style that I guess is a corollary to what Judge Tinder had to say is that on the district court, I had plenty of projects that I could handle in 15 minutes or so. Motions to compel discovery or case management disputes that could be dealt with fairly quickly. The circuit court provides very few 15-minute projects. You have to, on anything that's going to be producing a precedential opinion, you need to dig in much more deeply, as Judge Tinder said. One other interesting difference, at least for me, I often would hold oral arguments on contested motions as a district judge, and I would try to prepare and ask some intelligent questions. And at the end of the argument, I'd say, "Thank you very much. I'll take the case under advisement and get back to you in due course." In the Seventh Circuit, we say much the same thing, but you walk off the bench at the end of a day of oral arguments, and you discuss the cases and cast tentative votes immediately. What that means is that the decision-making process is much more front-loaded in the Court of Appeals than it is in the district court. Our votes after argument in those conferences are not final, but they do tend to be very sticky, and you need to be very well prepared for oral argument, not just as in trying to communicate to the parties, yes, you understand their issues in their case, but you are ready to make a decision in the case today. and so you have to try to do the hard thinking ahead of time, and then use your time in oral argument to help refine your thinking, and share your views with your colleagues. That's been that was an immediate difference that made me change the way I prepared for oral argument within a matter of just weeks, as I understood what was happening.
David's comment about always needing someone else to get anything done on the circuit court is so apt. And I recall early on, I think it was Judge Bill Bauer said to me, you know, John, you have to keep in mind on our panels that your enemy today you may need as your friend tomorrow. And so there are coalitions on various cases that shift from time to time. But it was fascinating for me, having been a district judge for 20 years, to walk into the conferences after argument, and I felt like I was walking into conversations that had been going on among my colleagues for 30 years. Some of them had been together 30 or more years, and decades, literally. And they've been talking about the Fourth Amendment. They've been talking about aspects of privacy. They've been talking about the Second Amendment and so forth in many cases before I came along. And so I had to get up to speed in those conversations pretty quickly. And they were very patient with me and so forth. But I felt like I was entering conversations that had gone on long before I came along. And I needed to get up to speed pretty quickly. So that was a big transition for me.
Mm-hmm. That's a great point, and I experienced that as well. And now, having been on the federal courts for a while, we're having new colleagues who are coming in, sometimes without judicial experience, and I'm the one telling the new folks about what we've been arguing about over the last 20 or 30 years, and what that dynamic has been like. I would also say that John and I both have had the privilege of serving on the Seventh Circuit with some brilliant colleagues. And suffice it to say, you've got to have your A game with you every time you sit in on oral arguments in the Seventh Circuit, and that. So the challenge of being ready, for example, to debate a Dick Posner on an issue in which you may well disagree, and then to try to swing the third panel member, or the challenge of being the third panel member in an ongoing debate between two of your colleagues, is one that took some getting used to. It also is what makes the job very, very interesting. And it does help, though, on the circuit court, if you have a very high boredom tolerance, so that you can enjoy debates over exactly what this particular paragraph in the opinion ought to say, which is a process that most district judges don't have the time for, and few have the patience for, particularly in a district as busy as the Southern District of Indiana was when Judge Tinder and I were district judges there, and even more so now as its caseload has continued to increase.